Guys, let's discuss something very important when it has to do with entering into contracts. Whether it is a contract of sale or anything, maybe you purchase a land, a property, or any kind of money transaction that you are involving yourself in, and you want to draft an agreement. I want to talk about a part that is usually very, very important. Now, the reason why we enter into agreement is not just because if something happens, we can go to court to seek redress. It's not just that. There are some little things that matters when you are entering into contracts. What even determines if you are going to have any remedy if you go to court to seek redress is some little things that reflects in the contract agreement. Now, I have two agreements in my hand here. This is a contract of sale that was done for someone. I didn't prepare it. I stumbled on it some time ago and I said I'm going to use it to make a video and educate people. And this is a deed of assignment, okay, transferring property to another person. Now I want to show you one very important thing. When you are entering into an agreement, especially if you are the one donating money, okay, if you're the one paying money to buy something, please don't always neglect this part, because this is what will determine if, for instance, God forbid, something happens to you, the chances of your beneficiaries or successors to have access to that money that is involved, or if it is a property, the property that is involved, the chances of them claiming the subject matter. Let's say, for instance, someone purchases a property. You know, death is inevitable. It can happen at any time. Someone purchases a property and he dies. Do you know that that person's representatives or successors, or let me just say children, may not be able to have access to that property? Yes, it depends on how the contract was drafted. It depends on how the deed of assignment was drafted. Now let me read something. This contract of sale was made between someone, and they just drafted the name of the person, hereinafter referred to as the vendor of the one party. They did not include his assigns, they did not include his personal representatives, they did not include successors in title, just the person's name. So this contract of sale now, let's just assume that they still use this method on the deed of assignment without including his successors, his representatives, and otherwise. If this person dies now, it ends here. Nobody can claim this property, except the people who sold that property are very, very kind enough to call them and say, oh, you bought your brother bought a property here, your husband or your father bought a property here, please come and take your property. If not, they cannot claim. They cannot claim that property. And now this one reads, this agreement is made between the name of the person, hereinafter referred to as assignor, which expression shall, where the context so admit, includes his assigns, executors, administrators, personal representatives, and successors in title. What this means is that if this person, if anything happens to this person now, his successors, his executors, his assigns, his personal representatives can come and sue and claim this property. So this is one part that people should not always neglect when they are entering into contracts. Always ensure that you read through, especially, like I said, if you are the one parting with money, because you will be the one to lose. I hope this video helps you. Please don't always neglect little things like this. Thank you so much for watching. See you in our next video. Bye.